I'd like to welcome everybody to the 20th day of the session, Tuesday, February 7th, 2023. So a little today in history. So we've all thought there's been a tough winter, and in some places there has been a tough winter this winter. But so from February 7th of 1872, snow continues to prevent trains from traveling from Cheyenne to Denver as it had since December 20th. Roll call.
Alaman. Allred. Andrew. Angelos.
Excuse.
Banks. Bear. Berger. Brown. Burkhart. Byron. Chadwick. Chestick. Plouston. Conrad. Crago. Davis. Eklund. Haroldson. Harshman.
Excused.
Einer. Henderson. Hornock. Jennings. Knapp. Larson Lloyd.
Excused.
Larson JT. Lawley. Luck. Nyman. Newsom.
Excused.
Nicholas.
Excused.
Nemec. Northrop. Oakley. Obermuller. O'Hearn. Olson. Ottman. Pendergraft. Penn. Provenza. Rodriguez Williams. Sherwood. Singh. Slagle. Smith. Stith. Storer. Strock. Stivar. Tarver. Trujillo. Walters. Ward. Washut. Western. Winter. Wiley. Yin. Zwaniter Dan. Zwaniter Dave. Speaker Summers.
Here.
Harshman.
Chief, let's keep that roll open. I would like to welcome Reverend Mark Marston, First United Methodist Church, for our prayer of the day. Please rise.
Please bless these men and women as they focus on what binds us and not what separates us, that they may be bridge builders, connection makers, that they may focus on what is in common, that they might allow these seeds to grow, that they may be these who hear others, their perspectives, that they may hear what others have to say. For these things we pray through Jesus Christ. Amen and amen.
Amen. Thank you, Reverend Marston. Please join me in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Everybody. After we come back in. House will please come to order. Chief Clerk, please finish the roll.
Larson Lloyd. Newsom.
Excused.
Nicholas. Sixty-one present, one excused.
Journal Committee report.
Your Journal Committee reports that the Journal of February 6th, 2023 has been read and recommends that it be approved. Representatives Chestick and Ward.
Representative Lawley, do you have a privilege?
Thank you, Mr. Speaker, for the privilege of the floor.
Please.
Ladies and gentlemen of the House of Representatives for the state of Wyoming, it's my pleasure to introduce some of my family to you. If you will look up to what I'm told is the north side, but I don't know that for sure, gallery, is some of my family. My husband, Roger, who many of you already know is a great guy, but I want to publicly thank for all his support that he gives me and allows me to be here to do this, and it is not without some sacrifice. And so that's my husband, Roger. And on the other side of the cute little girl is my daughter, Katie, our middle daughter, who serves our community in Worland as a nurse in a family practice clinic. Roger and I are learning as we're aging that the best investment we have made so far in our life is her education. So we are very proud of all of our children, but she has helped us out a lot. But last but not least is my granddaughter, Macy, who is beautiful, funny, and brilliant. And you need to know, Mr. Speaker, that sometimes she watches us online from Worland, and sometimes she borrows her mother's cell phone, and I will receive texts. And the text begins this way: Nana, it's Macy. I have a few questions. And in many ways, Macy embodies to me the future of Wyoming, which is so bright, and the reason I'm here. So would you welcome my family?
Welcome to the House. Representative O'Hearn, you have a privilege?
Mr. Speaker, privilege of the floor.
Please.
You mention each morning all the cool things that happen on this date in Wyoming. I don't know if she was born in Wyoming, but on this date, Trey Sherwood was born a couple years back. So everybody stand up. It's her birthday today.
To you, happy birthday to you. Happy birthday to you. Woo! Representative Henderson, privilege?
Thank you, Mr. Speaker. Privilege of the floor.
Please.
Thank you. You know, this is one of the most fun things that we get to do here, and while you're all standing up, I'd just like to look over here. We have some students from East High School, FFA, with Mr. Joe Allen. I just want to mention this is high school's number one in your heart, you know, never gets old. Hey, welcome to the House. Appreciate it. Let's give them a good welcome. Thank you for what you do.
Future Farmers of America, welcome to the House. Messages from the Senate.
Message 252. Mr. Speaker, the Senate adopted the Committee of the Whole report, failing the bill listed below by the vote indicated. Senate File 166, Border Wall and Sanctuary City Transport. Ayes 12, noes 18, one excused. Sincerely, Ellen Thompson, Senate Chief Clerk.
We are at that order of business of introduction of the Senate Budget Bill. Senate File Number 1. Reading clerk.
Senate File 1, sponsored by Appropriations. General Government Appropriations 2.
First reading of the bill.
An act relating to supplemental appropriations for the operation of state government for the fiscal biennium commencing July 1st, 2022, and ending June 30th, 2024.
Pursuant to Joint Rule 14-1E1, Senate File Number 1 is referred to Committee Number 2, Appropriations. The next Senate file for our consideration is Senate File 25.
Senate File 25, sponsored by Judiciary.
First reading of the bill.
District and prosecuting attorneys bar license requirement.
Senate File 25 is referred to Committee Number 1, Judiciary. The next bill for our consideration is Senate File 32.
Senate File 32, sponsored by Judiciary.
First reading of the bill.
Prohibiting drones over penal institutions.
Senate File 32 is referred to Committee Number 1, Judiciary. The next bill for our consideration is Senate File 82.
Senate File 82, sponsored by Water.
First reading of the bill.
Eligible water and sewer projects funding.
Senate File 82 is referred to Committee Number 2, Appropriations. The next bill for our consideration is Senate File 118.
Senate File 118, sponsored by Appropriations.
First reading of the bill.
Fund balance calculations, federal encumbrances included.
Senate File 118 is referred to Committee Number 2, Appropriations. The next bill for our consideration is Senate File 41.
Senate File 41, sponsored by Revenue.
First reading of the bill.
Skill-based amusement games, authorized locations.
Senate File 41 is referred to Committee Number 3, Revenue. The next bill for our consideration is Senate File 63.
Senate File 63, sponsored by Revenue.
First reading of the bill.
Tax administration revisions.
Senate File 63 is referred to Committee Number 3, Revenue. The next bill for our consideration is Senate File 84.
Senate File 84, sponsored by Senator Ellis.
First reading of the bill.
Education, model student attendance policies.
Senate File 84 is referred to Committee Number 4, Education. The next bill for our consideration is Senate File 74.
Senate File 74, sponsored by Agriculture.
First reading of the bill.
Slow-moving vehicles, amendments.
Senate File 74 is referred to Committee Number 5, Agriculture. The next bill for our consideration is Senate File 59.
Senate File 59, sponsored by Travel.
First reading of the bill.
State Parks Account, Agency Expenditure Authority.
Senate File 59 is referred to Committee Number 6, Travel. The next bill for our consideration is Senate File 75.
Senate File 75, sponsored by Blockchain.
First reading of the bill.
Decentralized Autonomous Organizations, amendments.
Senate File 75 is referred to Committee Number 7, Corporations. The next bill for our consideration is Senate File 19.
Senate File 19, sponsored by Transportation.
First reading of the bill.
Highway Safety, Child Restraints.
Senate File 19 is referred to Committee Number 8, Transportation. The next bill for our consideration is Senate File 20.
Senate File 20, sponsored by Transportation.
First reading of the bill.
Driver's License and ID Card Photo Quality.
Senate File 20 is referred to Committee Number 8, Transportation. The next bill for our consideration is Senate File 122.
Senate File 122, sponsored by Senator Driscoll.
First reading of the bill.
Non-resident workers, vehicle registration extension.
Senate File 122 is referred to Committee Number 9, Minerals. The next bill for our consideration is Senate File 7.
Senate File 7, sponsored by Senator Baldwin.
First reading of the bill.
Definition of opiate antagonist amendment.
Senate File 7 is referred to Committee Number 10, Labor. The next bill for our consideration is Senate File 26.
Senate File 26, sponsored by Labor.
First reading of the bill.
Psychology interjurisdictional compact.
Senate File 26 is referred to Committee Number 10, Labor. We are at that order of business of bills on second reading. The first bill for our consideration is House Bill 4. Oh, yeah. Oh, I guess we're not ready for that. Reports from standing committees.
Senate File 36, sponsored by Capital Finance, Investment Funds Committee, Selection Panel Amendments. An act relating to the investment of state lands. Mr. Speaker, your Committee Number 2 Appropriations, to whom is referred Senate File 36, Investment Funds Committee Selection Panel Amendments. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Walters. Noes, Representative Zwanitzer. Excused, Representative Stith. Representative Nicholas, Chairman.
That was a short list. All right. So now we are at that order of business of bills on second reading. The first bill for our consideration is House Bill 4.
House Bill 4, sponsored by Labor, Medicaid 12-month postpartum coverage, an act relating to medical assistance and services.
House Bill 4 having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is House Bill 38.
House Bill 38, sponsored by Transportation, Wyoming National Guard member referral, an act relating to defense forces and affairs.
We have amendments. Representative Pendergraft.
Thank you, Mr. Speaker. I bring second reading amendment number 1 to House Bill 38 and ask for your favorable consideration. A pretty simple amendment. In discussing this situation with the members that came and testified, the members that would be responsible for the operation of this program, I asked them if in the overall budget they had the funds to be able to operate this program. They said they absolutely did, but they said it's not in the right column. We can't move it from where we need it. And so my thought was, rather than start an entire new channel where we got to go squirrel away some more money, that at least for the next year, we allow them to reappropriate some funds to try this program out. Should this amendment be adopted, I would recommend a third reading amendment, which would put a sunset on this or a repealer. This is something that I would rely more heavily on those that are more experienced than myself to recommend the best way to handle this. It just seems to me that this is a good program. I like the program. I like the idea. But if the funds are already there and we can access them with a simple amendment like this, that's what I would like to do. Therefore, I do ask for an aye vote on this amendment.
Representative Pendergraft, just in case you didn't move that, would you move that amendment, please?
I'm sorry, he needs to move it?
No, you need to move it.
I believe that I did.
Well, there was a debate
Okay.
on that, so if we would just get you to
Okay,
remove that, we'll be all
I'll
right.
redo that. I move second reading amendment number 1 to House Bill 38 and ask for your favorable consideration.
Thank you, Representative. Chairman Brown, for your first time.
Thank you, Mr. Speaker, and I think it's important maybe for the body to just rehear the debate, and it's just one of those things that when it comes to rules that we don't bring amendments to bills, we move them, and I think that's exactly what the process was just now. But ladies and gentlemen, on and against this amendment, and for a simple reason. This is a 3-year program to get us up and running, to get us started to see if this program actually benefits and actually does what it's supposed to do. There is an appropriation out of the general fund, and anything that is not spent will get reverted back. I think there was a little bit of a misunderstanding on how the discussion was portrayed in committee about this program and whether or not you have enough money to set up the program. And the answer is, yes, they have enough money inside the agency right now if they had to do this with a certain amount. But when I asked them what their reversions were going to be as of July 1, it's only about $11,000. So that doesn't quite supply what we're expecting and or hoping to attract new referrals and new members of our active duty our guard member forces. So this is while it's a good intent behind this to say, hey, find the money that you've got. This is not providing the level of money that they have asked for and that they expect to actually provide with this coming out of here. So I would simply ask for a little bit of a pushback on this particular amendment, and let's stick with the military department and ask them to just go ahead and fund this program the way that we have asked to do it so far, and let's get our strength of forces back up to 100%. Thank you, Mr. Speaker.
Representative O'Hearn for your first time.
Thank you, Mr. Speaker. On and against the amendment for the bill. The good military people that were here earlier, it's all about manning strength and getting the people to come into the Guard. We've heard the two different programs. This one incentivizing the soldiers to get peer-to-peer recruiting, and also the additional educational benefits. These guys are our sword and shield. We need to protect them and get them the programs they need and the money they need. Against the amendment for the bill.
Anybody else for their first time? Anybody for their second time before the sponsor? Does the sponsor want to take another bite at the apple? Representative Pendergraft.
Thank you, Mr. Speaker. Still on and for the amendment. There was a reduction. Originally, when this came out, they asked for, I believe, was $808,000. That amount was reduced to, if memory serves, about 215, somewhere in the 200,000 range. That money is clearly available in the funding that they have, as far as I can tell. Anyway, I do ask for an opportunity for them to test this out for a year, and then we'll look at it again in the future and see if this actually works before we just dump a bunch of money in there. Thank you.
All those in favor of second reading amendment number 1 to House Bill 38 signify by saying aye. Aye. All those opposed? No. Second reading amendment number 1 to House Bill 38 has failed. House Bill 38 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is House Bill 59.
House Bill 59, sponsored by Transportation, Wyoming National Guard tuition benefits, an act relating to Defense Forces and Affairs.
House Bill 59 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is House Bill 89.
House Bill 89, sponsored by Capital Finance, state investment returns, adequate reserve funding, an act relating to the investment of state funds.
We have amendments. Representative Stiff.
Mr. Speaker, I respectfully withdraw my amendment.
Yay. Second reading amendment number 1 to House Bill 89 has been withdrawn. House Bill 89 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no.
Point of order.
Oh, I don't have another amendment in front of me. I'll wait for the amendment. All right. A good little amendment, I guess. Here we go. Representative Harshman.
Thank you, Mr. Speaker. I'd move second reading amendment number 2 to House Bill 89. Ask for your favorable consideration, support. Members, 89 is really a good bill, and we want to add another big trust fund to this. Where's the point?
Representative Pendergraph, what is your point?
Mr. Speaker, I believe we're on Bill 59.
89,
My mistake.
we had.
Okay, thank you, Mr. Speaker. And so members, on House Bill 89, second reading amendment number 2, second reading amendment number 1 was withdrawn. It's on your computer. And basically, this just adds, along with our other trust funds, the spending policy for the Wildlife Natural Resources Trust Fund. We have now proposed in this budget to move it from 187 to 200 million, the original goal, really from the 1980s when our predecessors. And I learned about it when I was, I think, a freshman on the TRW committee back in '04. And so anyway, now we've done a great job. We've saved our excesses. Now we want to put this into motion where there's a consistent budgeted amount that everybody kind of knows what they're dealing with there. So we'd stand for any questions. Thank you, Mr. Speaker.
Anybody for the first time? Cinching your urge to vote? All those in favor of second reading amendment number 2 to House Bill 89 signify by saying aye. Aye. All those opposed? No. Second reading amendment number 2 to House Bill 89 is passed. Senate File 89 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it's so ordered. The next bill for our consideration is House Bill 95.
House Bill 95, sponsored by Representative Rodriguez Williams, Working Animal Protection Act, an act relating to counties, cities, and towns.
We have amendments. Representative Sherwood.
Thank you, Mr. Speaker. I move second reading amendment number 1 to House Bill 95 and ask for your favorable consideration. So my constituents contacted me about this bill, questions, and feeling that there was maybe a loophole that didn't take into consideration puppy mills or animal hoarding situations. I dug a little deeper and found out that there's a few of our communities that already have ordinances on the book to regulate these. Those include Laradice over the hill, where the water springs sweet, where the wind mills blow, and the land of the trailblazers. So wanting to be respectful of those local ordinances and make sure that this bill doesn't supersede local government, both city and county's ability to regulate puppy mills and animal hoarders, I bring you this amendment.
Anybody for their first time? Representative Rodriguez Williams for your first time.
Thank you, Mr. Speaker, and thank you to the bringer of the amendment. So I did consider this when drafting the bill. Yes, there are ordinances that prohibit puppy mills. However, we also have statute that defines cruelty to animals. And so it's my understanding that puppy mills are not explicitly illegal through state statute. However, they would be if the puppy mill met the definition of animal cruelty under 631002, titled Cruelty to Animals. So I've double checked this a few times when drafting the bill and when it went through committee. And I guess I would just say that vote your conscience on this one. Thanks.
Representative Penn for your first time.
Thank you, Mr. Speaker. I just have a question for the bringer of the amendment. Do we have a definition of what constitutes animal hoarders? Thank you.
Anybody else for their first time? Anybody for their second time before the sponsor? Representative Sherwood for your second time.
Thank you, Mr. Speaker. Yes, and thank you for the question. So in our Wyoming statute 631003 prohibits confining animals in conditions that constitute a public health hazard. So really that is the idea that there's not adequate food, water, or shelter for our animals. Really is the ordinance that addresses puppy mills and hoardings. But at the local level, those 4 communities I mentioned, they have definitions in their local ordinances.
All those in favor of second reading amendment number 1 to House Bill 95 signify by saying aye. All those opposed? No. The chair is in doubt. All those in favor of second reading amendment number 1 to House Bill 95, please stand. Bear. Bear. All those opposed, please stand. Less than 35. So second reading amendment number 1 to House Bill 95 has passed. House Bill 95 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is House Bill 98.
House Bill 98, sponsored by Revenue, Property Tax, Homeowners Exemption, an act relating to taxation.
House Bill 98 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is House Bill 101.
House Bill 101, sponsored by Representative Crago, Uniform Trust Code Amendments, an act relating to trusts.
House Bill 101 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is House Bill 108.
House Bill 108, sponsored by Representative Summers, Sale of THC vaping devices and edibles to minors prohibited, an act relating to children.
Representative Zwanitzer, Chairman Zwanitzer.
Thank you, Mr. Speaker. Can I get a quick privilege of the floor first, if I ask nicely?
Please.
Thank you. Ladies and gentlemen, I've probably disappointed my parents a couple times in life just a couple, because my father was the chapter vice president of FFA, and I was a 4-H'er, but I didn't go into FFA, even though I did marry the state vice president of California's FFA. But I tried, and I'm an honorary lifetime member. But the second half of our Cheyenne FFA chapter is upstairs in the South Gallery, including in the front row, that guy standing, his turkey is hanging out in my front yard right now. But if you'd please welcome the second half of Cheyenne FFA.
Welcome FFA, more future farmers. I like it. So now,
Mr.
Chairman
Speaker,
Zwanitzer.
I would be pleased to move second reading amendment number 1 to House Bill 108. And so, ladies and gentlemen, this is the continued conversation we're having on these products. And so after consultation with our Department of Health and our AG's office and our Chief Executive's office, we're trying to add some language into the bill that covers analogs. And so you see there's 2 parts of this amendment. On line 7 through 14, we're really trying to add analogs of these tetrahydrocannabinols into our statute. And then there in the second part, when we talk about controlled substance analogs, we're further defining that as long as they have some effect on your nervous system to equal or greater value, either depressant or hallucinogenic, also putting that in the statute. I think that addresses the concerns we're having on some of these derivatives of these THC products. And after checking with members of the executive branch, this is the language we've come up with to insert in the statute to hopefully cover them. Be happy to answer any questions.
Sensing a need to vote, all those in favor of second reading amendment number 1 to House Bill 108 signify by saying aye. All those opposed. Second reading amendment number 1 to House Bill 108 is passed. House Bill 108 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is House Bill 118.
House Bill 118, sponsored by Representative Newsom, Volunteer firefighter pension funding, an act relating to volunteer firefighter, EMT, and search and rescue pension account.
House Bill 118, having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is House Bill 143.
House Bill 143, sponsored by Representative Ward. Health mandates, CDC and WHO jurisdiction in Wyoming. An act relating to public health and safety, prohibiting health mandates and requirements by specified federal and non-governmental health organizations as specified.
We have amendments. Representative Henderson.
Thank you, Mr. Speaker. Members, I move second reading amendment number 1 to House Bill 143 and ask for your favorable consideration. You know, on reflection and looking at this bill quite a bit yesterday and last night, I think this has some merit. And I think we could tighten up this language a little bit. I'm not all the way there yet, but I wanted to offer this amendment for your consideration. So if you look at page 1, line 2, after requirements, I'm recommending amending it to read that negatively impact the people or any jurisdiction in Wyoming. And why do I offer this? Well, here's why. We have millions of dollars in health infrastructure across our good state. And why would we cut off our nose to spite our face if there was a recommendation that would benefit Wyoming and our people? Then going on to page 2, line 1, because of the applicability to certain provisions of the Constitution, I recommend amending before the, notwithstanding the applicable provisions of the United States Constitution and the Wyoming Constitution. And I'll just continue on reading. The next line after shall, delete the balance of the line, and then the paragraph continues, shall not impose any requirements or health-related mandates that negatively impact the health and public safety of any person, including any jurisdiction, county, city, or town in Wyoming. After the Department of Health reviews the United States Centers for Disease Control and Prevention of the World Health Organization's requirements and makes a recommendation to the governor for final approval, then the requirements may be imposed. And the purpose of this, as I said before, is that I think it's 2023 and there's a lot of good technology and research out and about. So I think it's worthwhile for this infrastructure that we paid so much for, to take a moment and just check it out and see if it's something that we may. It doesn't say shall, it says may. So I don't think this interferes with the merit or potential merit of this legislation. And then because of the urgency, you know, health things are important, right? And so rather than wait till July to implement it, my last recommendation is to amend the effective date to immediately. And that's the substance of my proposed amendment. Appreciate any questions. Welcome to conversation.
Representative Ward for your first time.
Thank you, Mr. Speaker. On and against this amendment. It's based on subjective findings and feelings about effectiveness, harm, which is going to have to be adjudicated in the courts, and that is not the intent of my bill. I'd like to remind everyone that our presidential executive branch of the best country in the United States, or the best country in the world, the United States of America, hopefully I can say that here, has ended this emergency effective in May. Furthermore, this bill has already been amended to only apply to COVID-19 and its variants. I believe its scope is narrow enough that this bill does not need this amendment. I consider this amendment unfriendly. Please vote against it. Thank you.
Representative Penn for your first time.
Thank you, Mr. Speaker. I stand in strong opposition to this amendment. The words negatively impact the people are very subjective. Whose definition of what is negative impact are we allowing here? And especially with regards to what's been happening recently with COVID, we're still having those discussions 2 and 3 years later on what was negative and what wasn't. And so if you're saying that, and this doesn't say who's going to be making that judgment on what is negative. And a lot of times in these situations, when we're talking about these urgent matters, we don't have any information to go off of yet. And so the whole point of this bill is to avoid situations like this where the wrong people are making those judgments for the people. The people need to be making the judgments for themselves. And when these mandates are being imposed upon us, we are disallowed from making those judgments for ourselves. On and against.
Representative Larson, JT, for your first time.
Thank you, Mr. Speaker. On in favor of this amendment, I think that this provides some wiggle room within the bill as it's written, and I ask for your aye vote.
Anybody else for their first time? Representative Locke for your first time.
Thank you, Mr. Speaker. I think that the amendment basically distorts the intent of the bill. The point here is that these organizations don't have jurisdiction here, and that's what we're trying to stick to. So I'm on and against the amendment and for the bill.
Anybody else for their first time? Anybody for their second time before the bringer of the amendment? Representative Ward for your second time.
Thank you, Mr. Speaker. If permissible, in accordance with Rule 12-4, I ask for a recorded vote on this amendment.
That take a second. Simple, 1 second. See the second Jennings. So Representative Henderson for your second time.
Thank you, Mr. Speaker. So I didn't really hear any questions in there, but I'll try to address the highlights of what I did hear. Regarding the bill, this does not change the core focus or objective of this bill. In fact, I think it improves it because it recognizes, as I said, the millions of dollars that the state of Wyoming, all across our state, has invested in the infrastructure related to healthcare. As far as COVID-19, you know, we didn't know COVID-19 was coming when it came. And I would submit respectfully that we don't know if it's gone. Flu isn't gone. We get a different version just about every year, different vaccination. And the most important thing here is the applicability to the Constitution. We all know that because of there's various clauses. I mentioned them briefly yesterday, the preemptive provision and so forth. We don't tell a federal agency what to do. Title 42 in the federal register rules covers this. I'd be glad to show it to you. And it's been litigated. It was litigated back when they had smallpox. And we all can make our own personal decisions, right? You go to the bathroom, you make a decision whether you wash your hands and use soap or not. You go to the hospital or not. You go to the emergency room or not. That's a personal decision. I'm not getting in the way of that one bit whatsoever. And as far as the other comments, I would just suggest that this is second reading, and I'm certainly open to amending this revision and open to conversation, as I said, on how you folks would like to maybe improve this. I think it's a big mistake and perhaps somewhat short-sighted. I mean no disrespect to the good bringer and the co-sponsors, but We didn't know about COVID, and we learned a lot since. And I think for the most part, many of us are better off knowing what we know now that we didn't know then. And I'm just suggesting that we take that opportunity now to consider this before we go out and just, draw a line in the sand. Where does it stop? It's this agency, federal agency, and so on, right? So I'd really urge a careful consideration and ask for your aye vote. Call for the question, Mr. Speaker.
All those in favor of second reading amendment number 1 to House Bill 143 signify by saying aye. Oh, we had the ayes and noes, sorry about that. All those, Chief Clerk, please call the roll.
Elliman? Allred? Andrew? Angelos? Banks? Bear? Berger? Brown? Burkhart? Byron? Chadwick? Chestick? Clauston? Conrad? Crago? Davis? Eklund? Haroldson? Harshman? Heiner? Henderson? Hornock? Jennings? Knapp? Larson Lloyd? Larson JT? Lawley? Locke? Nyman? Newsom? Nicholas? Nemec? Northrop? Oakley? Obermuller? O'Hearn? Olson? Ottman? Pendergraft? Penn? Provenza? Rodriguez-Williams? Sherwood? Singh? Slagle? Smith? Stith? Storer? Strock? Stivar? Tarver? Trujillo? Walters? Ward? Washut? Western? Winter? Wiley? Yin? Zwanenser Dan? Zwanenser Dave? Speaker Summers?
Aye.
Are there any changes? Hornock? Davis? Aye to no. Further changes? Olson? Aye to no. Provenza? Aye to no. Further changes? Closing vote? Vote closed. 26 aye, 36 no.
Second reading amendment number 1 to House Bill 143 has failed. House Bill 143 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is House Bill 152.
House Bill 152, sponsored by Representative Rodriguez-Williams. Life is a Human Right Act, an act relating to abortion.
It has amendments. Representative Western.
Thank you, Mr. Chairman. I move second reading amendment number 1 to House Bill 152, and I ask for your favorable consideration. Okay, so I know this is a super contentious one, but if you kind of listen to the debate, one of the concerns is the unconstitutionality. And I am certainly not an attorney. I will defer to the attorneys that we do have to elaborate further, but even I can tell you that in the Constitution, that delineation of powers, that separation of powers between our branches is extremely important. It's in the US Constitution and it's in the Wyoming Constitution. So what this amendment does is if we look at the bill on page 12, it just pulls out the right of intervention. The concern is, as currently written, we are allowing a path for the legislature to appoint someone to intervene in a court case. If that's not a clear violation of separation of powers between the legislative and the judiciary, I don't know what is. Sure, someone can say, well, it says may, not shall, but I think the point or the principle of it is by virtue of us allowing this path to happen in any way, explicitly in law, has a lot of concerns when it comes to the separation. So that's what this amendment does. I think it it certainly addresses one of my major concerns, and if you listen to the debate, I think it concerns of a lot of folks. So I think let's go ahead and tighten this bill up. Please vote aye. Thank you.
Representative Pendergraft for your first time.
Thank you, Mr. Speaker. Question for the bringer. Could you explain to me the difference between intervention and a witness or testimony? Thank you.
Anybody else for their first time? Representative Rodriguez Williams for your first time.
Thank you, Mr. Speaker. So on and against the amendment, yes, we did discuss this at length yesterday. However, there might perhaps be a little bit of confusion about the way the bill is drafted regarding intervention. The bill does state that those that are appointed by joint resolution of the legislature would have the right to intervene. So thus it would require a separate resolution. More than likely, as we discussed yesterday, House Bill 52, if it were challenged, it would be challenged right away. And so those that are invested in the bill would be the ones that would be allowed to intervene through the resolution. If it were 20 years down the road, then the bill would save lots of babies' lives, as it should and is intended to. On and against.
Chairman Zwanitzer for your first time.
Thank you, Mr. Speaker. On and in favor of the amendment, and honestly not related at all to this bill, but just to the precedent we're setting. It just seems like a bad idea that every time this body is going to put forth some legislation that we know or we assume might be challenged, right? Our good attorneys in the legislative branch normally tell us, and they'll put a memo together saying, you know, your bill may or may not be constitutional and there's a question there. I just think it's a bad precedent to set that every time we pass something we know might be challenged, we're going to appoint one of our members to defend it in the legislative branch, not even one of our attorney members, just one of our members to go in the Supreme Court. It just seems very odd. And then it seems even more odd that we would make it that it has to be somebody who's a sponsor or a co-sponsor of the bill. I mean, we all know what happens to bills, and sometimes they don't look at all like what a bringer brings by the time they get through the entire session, and that name may not even support what the final action is on the legislation. So it just seems a very weird step, not even related to this bill, that we will start the practice of having a legislative designee to go defend any of our bills should they be challenged in our highest court. And so I do think it's a good idea to take this out of statute. It's a bad precedent to set, and I'd ask for your aye vote.
Representative Ottman for your first time.
Thank you, Mr. Speaker. Just a question for the group that's against this. Oftentimes in committee, the wonderful things about our committees is that we get to hear testimony from so many different sides. We get to hear people for it, against it, people that work in that line of work, people that just have a touch of it, people that are hired to fight for it. And so with this, is it not to provide more information for the court about the topic that there is? These people have worked on these bills for months. They have talked with experts on both sides of the line, and they have come up with the very best legislation that there is. Is their opinion not valuable? Thank you. I would vote no on the amendment and yes on the bill.
Representative Jennings for your first time.
Thank you, Mr. Speaker. On and against this amendment. Members, you look around you and look at this beautiful Capitol and all the money that was spent here. And at the time that that was done, there was a legislator here along with a citizen, and they were not given standing in the courts. So that's a good reason for us to defeat this amendment. We need to be able to push back to the courts a little bit and say, hey, if you want to know the intent, talked to some of the people that were involved in this. They have standing. They can actually come. I mean, who knows what the court will do, right? But let's keep that in the bill, on and against the amendment.
Representative Brown for your first time.
Thank you, Mr. Speaker. Ladies and gentlemen, you're about ready to hear from a good country lawyer who probably has a heck of a lot more experience than I do on this, but I did research this. As you know, I didn't get up and talk on this bill at all yesterday. I literally sat down, scribbled notes, heard discussion, heard what the body had to say, heard concerns, and then when I heard this concern, I actually went and used the interwebs to find out what's the precedence of this actually being utilized, not only just in Wyoming, but across the country. And this has been litigated and litigated and litigated in hundreds upon hundreds of cases for legislators to have standing in bills that they pass, that they feel that they have a personal connection to. And it has it has consistently been shown in the highest court of the land and in multiple courts of states that litigating this particular portion of this, a legislator does not have standing. In order to have standing, you have to personally be affected by the particular issue of the law. And unless, and I'm really, really bothered by the line that is on line 20 on page 12. It says, notwithstanding any other provision of law. We're going to put that in this law. So we say, notwithstanding any other piece of our green books, we are going to now make new rules for this particular law. That's really concerning to me. And I do feel like we're setting, not only as the good chairman of Labor Health said, a dangerous precedence, but it's actually already been set in precedence that this is not legal. We don't have standing as legislators to defend our own laws in the court of law. We have to be shown some level of harm and/or we have to have some level of standing, and we just do not have that just because we have a personal vested interest in seeing that our bill stays intact. So on and for this amendment, because I truly do feel, and as you'll hear from me in the coming minutes here, I want to make this bill better so I can vote for it. I truly do. And this particular amendment does make this bill better and gets us a step closer. So on and for.
Representative Craigo for your first time.
Thank you, Mr. Speaker. So you all heard me yesterday. I told you there are several provisions within the bill that I think are blatantly unconstitutional as written on their face. And this is one of them. So I'm in favor of the amendment, on and for the amendment. And let me explain why I think it's unconstitutional. We'll just dig into that a little bit. And to do that, we'll go back to like 5th grade civics class, right? 5th grade government. The legislature makes the laws. The executive branch enforces the laws, and the judiciary interprets the laws. We all have our lanes. And what this particular provision within the bill does is takes us as the legislature out of our lane. We now become the enforcer of the law, and that's not how the Constitution is set up. So that's the first problem. That's the first constitutional provision it violates, which is the separation of powers. The second one, and this one's a little more, I guess, nuanced, but it's kind of an interesting conversation, really, is Article 3, Section 27. If you open up your Constitution and look at that, it says special laws are prohibited, which really means you can't single out people, you can't single out towns, you can't single out individual little topics within bills. Any bill that can have a general application has to. Well, what this provision within the statute, proposed bill, does is essentially it takes the people's names who are at the top of the bill and puts them into statute by doing an end around. And so we're creating a special law for a certain class of people, actually names. And so if we're going to do that, why don't we just put their names in the law? Why don't we just write them right in the bill and say, these particular people who signed on to this bill are the only ones who are entitled to do this? I would submit to you that is unconstitutional. That is the prohibition in this book. That's what that's meant to do. And so those are the two reasons this particular provision, there's others that are unconstitutional, and we went through that yesterday, but I would tell you that's why I'm on and for the amendment today.
Representative Washut for your first time.
Thank you, Mr. Speaker.
The sponsor of the bill mentioned that part of the reason for this intervenor provision was to allow for legislative intent to be brought forth and considered by the court. So my question is for one of the lawyers in the room, might we be able to achieve the same thing with an amicus brief as opposed to being an intervenor in becoming a party to the suit? So one of the lawyers would chime in, please.
Representative Bear for your first time.
Thank you, Mr. Speaker. So Wyoming and Federal Rule of Civil Procedure states that parties may intervene if there's a statutory right. And we do this often. We put a statutory right in our laws so that people can intervene or they can be a party to a lawsuit. And I'll just give you an example where this has gone awry. And unfortunately, our courts are an imperfect system as well, just like this body and just like any other governmental entity, including our executive. There's imperfections. So in an effort to overcome some of those imperfections, we try to provide these methods for the law to be more accurate and the intent to be carried out and carried on. And this intervening opportunity in this bill is just that. Now, honestly, because interveners still have to meet certain requirements in the law to be able to be allowed to intervene beyond what this statute would do if we enacted this law, it's probably not that critical. So I'm going to ask you to vote your conscience on this particular amendment. It's not necessarily worded as I would word this amendment, but don't be afraid to put a statutory standing into law. I'll remind you of the election two elections ago when the 45th president of the United States was told in various court cases that he had no standing in the election. And it's important that we try to cover these unintended consequences, and standing is an important tool that this body can use. So I caution you to not throw out the baby with the bathwater in this case. I will vote for the amendment because I think it's important that we stand up for these things. Thank you.
Anybody else for their first time? Anybody there for their second time before the sponsor? Representative Jennings for your second time.
Yeah, members, I don't understand quite why we would be fearful of doing this. There's a severability clause in there. If the court deems this not constitutional, they can already take that out on and against this amendment.
Anybody else for their second time before the bringer of the amendment? Representative Brown for your second time.
Thank you, Mr. Speaker. Just briefly, the only other portion that I'm happy that we're bringing this amendment for is you have to be a member who sponsored or co-sponsored this act. I think, we heard yesterday in the discussion that once you have rape or incest included into the bill, it then becomes, you can't defend that because then it becomes discriminatory. And if I didn't co-sponsor this, but let's say I wanted to go defend this and I wanted my version of legislative intent, I don't have that ability now because I didn't sponsor or co-sponsor. And I again, ladies and gentlemen, I am truly trying to do what I can to make this bill a better bill. I do not want to see us kill bills. That is not what our job is to do. Our job is to make bills better and make the body feel more comfortable with voting for them. This particular amendment does do that. I understand the need, the want, and the necessity of protecting that precious piece of paper that you put so much time into to be challenged in the court of law, and you don't get the ability to stand up there and say what you wanted. But that is not our role as legislators. Our role is to create the law, let the executive branch enforce it, and let the judicial branch do the ones that adjudicate this law. That is what we are supposed to do. We need to stay in our lane. Thank you, Mr. Speaker.
Representative Rodriguez-Williams for your second time.
Thank you, Mr. Speaker. So what I hear is that there is concern about the intervention being interference with the judicial process. Again, on and against the amendment. It is the business of the courts to deal with parties. How a party obtains standing is not necessarily interference with the power of the court. Rather, it's a statement as to who has standing regarding the law. And yes, this bill does lay the basis for intervention for future litigation regarding this law. And then to the good country lawyers that spoke, or the country lawyer that spoke, I would just cite a Supreme Court decision, specifically Berger versus North Carolina State Conference of the NAACP. And in that court case, they found that the legislative appointment of representatives was appropriate. Legislative leaders were allowed to intervene. The Supreme Court did not get concerned about its authority. And the case set precedents for legislators to intervene. And so I'll remain a no vote on the amendment. Thank you.
Remember not to name organizations within lawsuits. Representative, anybody else for their second time? She left. Representative Washut for your second time.
Thank you, Mr. Speaker. Second question. If legislators intervene in a lawsuit, who pays the cost of that? Does that come out of our LSO budget? Just a question, who pays the cost?
Representative Bear for your second time.
Thank you, Mr. Speaker. I just want to correct my statement earlier. Again, I think that you should vote your conscience on this amendment because I think there are times when we do need to put standing into statute, but this may or may not be the time. And I had said that I was supportive of the amendment, and I am on and against it. That's the correction.
Anybody else for their second time? Representative Western for your second time.
Thank you, Mr. Chairman. Again, this is not an issue that's, or an amendment that's going to change our mind, but I think we have to think about this in the big picture. We got really good work done last year with the trigger bill. This is to improve on that. If we care about this legislation, it's pretty obvious that there are some serious constitutional concerns here, with this being the biggest. If we want to strengthen this bill and strengthen the intent behind the bill and ensuring it has the strongest case going into court, I would contend before you all that this amendment does that, that this is one less thing for the justices to be concerned about. Case was mentioned back east about the legislature appointing an individual in a certain court case. I would contend that was a bad call, that that was not the right move. Our founding fathers specifically wrote in many, many documents and in many volumes the importance of the judiciary to setting a precedent and interfering with judicial matters in the courtroom, the right call? I would say no. Respecting that strong judiciary is a really important component of our Wyoming Constitution and of the US Constitution. I think if we want this bill to have the strongest chance going into court, removing one of the biggest red flags in it, I think is the most appropriate course of action. Thank you, Mr. Chairman.
Question being called. Well, that was the last time of the bringer of the amendment. There is nobody else behind that. I made a call. You were the last one to come, so nobody else. All those in favor of second reading amendment number 1 to House Bill 152 signify by saying aye. Aye. All those opposed? No. Second reading amendment number 1 to House Bill 152 has passed. Division being called. All those in favor of second reading amendment number 1 to House Bill 152, please stand. All right, all those opposed, please stand. More than 24. Second reading amendment number 1 to House Bill 152 has failed. Next amendment for our consideration, Representative Brown.
Thank you, Mr. Speaker. I move second reading amendment number 2 to House Bill 152 and would ask for your favorable consideration. And ladies and gentlemen, I'm going to save the body a little bit of time here. I'm not going to divide it. I was going to send through like 13 or 14 different amendments, but really what I want to do is I want to walk through this entire amendment and explain exactly what we're doing with this. So as I stated, I listened to the debate all day yesterday. I did not speak. I listened and I wrote down the concerns, a little bit of the aggravations, and some of the ideas of how we can make this bill better. Our job is not to kill bills, but it is try to make them better. And this particular amendment simply takes the discussion from yesterday and attempts to make the adjustments that I heard come into the bill and make people feel more comfortable in voting for it. So what do? If you take a look, it looks like it's a very messy amendment, but I'm going to walk you through page by page on the bill so we can understand exactly what we're doing. Start out with page 2. If you go over to page 2, we change a little bit of language on lines 14 and 15, and we just say that the legislature is a co-equal branch of government, and we strike the remainder of that finding. So we get rid of the may make declarations of interpreting the Wyoming Constitution. That's the first change. Second change is on line 18. We get rid of the term from conception. This was out of the discussion of whether or not conception is really where we want to have that discussion of what is true life. And again, this is not me having this discussion, ladies and gentlemen. These are the concerns that I heard brought forward. Flipping over to page 3, we go down to line 9, and we get rid of this act promotes and furthers Article 1, Section 6 of the Wyoming Constitution, which guarantees that no person may be deprived of life or liberty without due process of law. I think it's an incredibly hard discussion to have. Due process of law with something that does not even have the ability to represent oneself. So I think that this is one portion of the bill that needs to be removed. Then going down onto lines 15 here, I strike out 1833 and Article 21 and Section 25 from this line. And I keep in a portion of this, but why did I do this? These are the ones that were brought up for the Good Country Lawyer that truly don't have much of an impact on the term of abortion and what we're actually discussing here, which is religious liberty, compensation for property taken, and then religious liberty in Article 21, Section 25 again. Then down below that, I strike out lines 20 through 23. And I want to make this clear. This is something that I am bringing forward. And this is very clear. What we are trying to do here is to scapegoat around the Constitution. We're trying to say that an abortion is not a medical procedure, and it is not health care. While I understand the intent to do that, we can say that all we want. I don't believe that jurisprudence would allow that to be occurring, and I don't think that this would be found to be a good piece of language to have in this bill to take forward, because while it may be a legislative intent, let's be clear about this, an abortion is a medical procedure. So flipping over to page 4, I strike line 12 and I go to delete from conception. And then I delete lines 14 and 15. And what I'm ultimately getting here to, ladies and gentlemen, is on page 6, I'll get there in a second, is I'm getting away from fertilization and conception to a heartbeat, where that is more fundamentally, I would say, understood. Not necessarily where I agree with, but what I would say is more fundamentally understood. And again, my attempt is to try to make this bill more appealable to the majority of this body so we can pass a bill that we more comfortably feel with. So strike that, then over onto page, keep going over here into page 6, we say that the new language would read as such: unborn baby or unborn human being means an individual living member of the species Homo sapiens through embryonic and fetal stages from heartbeat detection to full gestation and childbirth. So I'm just attempting to clean up a little bit of the language and trying to go into there. One of the other pieces that I forgot back on the findings is on page 5. is the new language that it says, "The legislature acknowledges that once an unborn baby's heartbeat is detected, a woman shall have no right to her own healthcare decisions with respect to the pregnancy." Strictly to the protection of the health of the pregnancy. And again, this is something that I believe we need to have in here. We need to say what we're truly trying to say. That the baby, the unborn fetus, is truly what the core of this bill is about. It is not about the rights of the mother. So when a mother has a detectable heartbeat inside of her, the healthcare decisions associated with that child reside not with the mother, but with the body and the government that is going to enforce this. Then the last thing that we have here was a conversation that was brought up yesterday. If you go all the way back to page 17, line 17, was a discussion if you have a mother that is on Medicaid, her life is in danger, and she goes into the emergency room, and the doctor treats her. As this bill stands, that doctor would not be compensated for the care because she was a Medicaid patient. They didn't break any laws because we would attempt to say that it was in the cause of saving the mother's life. They didn't break any laws, but we're not going to compensate them because she was a Medicaid mother. This really does become the discriminatory approach that I heard yesterday, that if you protect one portion, you've got to make sure you protect the other. And so I'm just literally trying to say that if you're going to allow this to happen and the mother is on Medicaid, we should be taking care of the doctor that performs the act and saves the mother's life. Okay? I want to also be clear that we are not paying for abortion with government dollars free for all. It is very tight language. I worked with our attorneys to make sure that this was the case. And it says, except if the pregnant woman is a Medicaid participant and when necessary to preserve the woman from a serious risk of death or substantial physical harm. I tightened that up as tight as I possibly could. Ladies and gentlemen, I've been in for 7 years now, and I think I've heard an abortion bill every single year. These two bills, the trigger bill last year and this bill, do exactly what I said. I would vote for these bills if they do what the problem is, and that is just get rid of abortion, right? There's too many unconstitutional issues that I see with this bill as it goes forward that I couldn't vote for this as it stands. I truly do want to protect the unborn, but I want to do it in a way that is lawful and legal. I'm sad that we lost the last amendment, but I'm not going to go back and fight on that. I think that we have another reading to make this even better. So maybe we can work with the sponsors of this bill and find a way to make this work. But yesterday, I voted aye on this bill to move it forward because I truly do feel that we have an option and an opportunity here to make this bill palatable for the majority of this body to vote for it and send it across the hall. With that, Mr. Speaker, I'll stand for any questions.
Representative Ward for your first time.
Thank you, Mr. Speaker. Let's be clear. The result of conception between two humans is unequivocally a human. If you're driving ahead and you see something that looks like it might be a person, but you aren't 100% sure, do you stop your car or just go ahead and run it over because you don't know for sure whether it's human? Obviously, you choose the path that might avoid the destruction of life. If we actually do not know when life begins, which is more egregious, if pro-life individuals are wrong, then a baby is born, sometimes under circumstances that might not be ideal. If the pro-choice side is wrong, a human being has been murdered. Which result is better to avoid?
Representative Bear for your first time.
Thank you, Mr. Speaker. I appreciate the effort by the bringer of the amendment to address all of the concerns that he has with this particular bill. Some of these things I agree with, actually, and some of them I don't. I think at some point he gets into the philosophy that was brought forth in the actual bill and tries to change it to a philosophy that is more agreeable with him. Those things I oppose. But some of these particular addressing, the legal issues and the concerns with Medicaid doctors, I could accept those. And I would love to divide this amendment. But you all know how I feel about dividing amendments, so I'm going to stand on principle and not do that. And I will ask that you oppose this particular amendment. And I would invite the bringer of the amendment to work with me on a third reading amendment to address some of these concerns. I think we can find some common ground there. But let's not change the philosophy of the bringer of the bill and those who've sponsored and co-sponsored it to something that it is not. Thank you.
Representative Heiner for your first time.
Thank you, Mr. Speaker. Ladies and gentlemen, as I read lines 25 through 27, I'm not sure I understand the intent of the bringer of this, the good bringer of this amendment. It says that the woman will have no right to her health care decisions with respect to the pregnancy. I'm not sure what kind of implications that would raise if that was passed. Would she not be able to decide which kind of vitamins or whether to take vitamins? What kind of food to eat? Could she not decide whether to have a C-section or a natural birth? Does this take all of the decisions away from this woman? I can't believe that we would pass something like that here in this free country. This sounds like a socialist government mandate right there. So I urge the body not to vote no on this amendment. That could have far-reaching implications. Thank you, Mr. Speaker.
Representative Penn for your first time.
Thank you, Mr. Speaker.
Just a quick note, we try not to say socialist and accuse people of being socialists at the mic.
Thank you, Mr.
Representative Penn.
Speaker. So I've been approached at times saying that early in a pregnancy, there's no difference between a fetus and a clump of cells. And my response to that, which is this: if left alone, will that clump of cells grow into a human? I've had people liken it to cancer. It's no different than cancer, that clump of cells. It's unwanted, it's there, it grows on its own. But if we let cancer continue to grow, does it grow into a child? We discussed yesterday about conception, and people have been trying to throw out that science hasn't settled on when life begins, but the scientific textbooks and journals and things all have a very similar definition of that, and that is when the ovum and the sperm unite. At fertilization is when conception begins. With regards to this amendment's technicalities, there are several things that I have issues with. Line 26 of the amendment, when it says heartbeat is detected. So the legislature acknowledges that once an unborn baby's heartbeat is detected, a woman shall have no right. The problem with that is it says when the heartbeat is detected. It doesn't say when the heartbeat can be detected. And then there's nothing in here that requires an ultrasound to be done. So we're saying that as long as a woman hasn't heard that heartbeat, then it's okay to perform an abortion. I've had teenage girls in my clinic come to me with complaints of weight gain and abdominal pain, only to find out that their pregnancy test is positive. And based on the size of their uterus and their belly, they're probably about 16 or 20 weeks along. She had no idea, or at least that's what she claimed. We never heard a heartbeat because we didn't have ultrasound capabilities in that clinic. So under this, that gal she hadn't heard her heartbeat, she could go get an abortion. She could go take the life of her baby. On line 34 of this amendment, page 17, line 17 of the bill, talking about including Medicaid participants to still be allowed to have funds for abortions. I think this could be better handled to achieve the intent here by just inserting the word elective in front of abortions rather than creating this class where Medicaid patients can still have their abortions paid for. On and against this amendment.
Representative Hornock for your first time.
Thank you, Mr. Speaker. I mentioned this yesterday. I just want to mention this again, that the federal government does sort of have an in-between the lines definition of when pregnancy begins, because they offer Medicaid coverage at proof of pregnancy. Proof of pregnancy can be done prior to what we think we might detect as a heartbeat. So the federal government believes that that fertilized egg is viable, so that they offer Medicaid coverage. They throw them under the umbrella of Medicaid coverage at conception, essentially. So the federal government does define this conception principle kind of in a backdoor way. So keep that in mind as you vote for this. Thank you. I would be on and against this amendment. Thanks.
Representative Jennings for your first time.
Thank you, Mr. Speaker. So the good bringer of this amendment brings it about for the purpose that we need to make it more palatable to vote for. First of all, I would remind you that it made it to second reading, so apparently there's a majority already. And I'm not sure that this makes it a much more palatable. And as I listen to the good bringer bring this, it would seem like that we'd probably be better off to bring a substitute amendment or a bill, as we're touching many parts of this. And I would argue that while there might be some things that might need to be touched, I would argue that this amendment is probably not ready for prime time either. So we have another reading. I'm going to urge the body to vote no on this, and let's if we're gonna mess with this at all, let's do it in a third reading, smaller way. Truly, I think that's the better way.
Representative Rodriguez Williams for your
Thank-
first time.
Thank you, Mr. Speaker. On and against the amendment for several reasons. The way I look at it is that the amendment is trying to use the findings in the bill to define that life begins when there's a heartbeat detected, which essentially is around 21 days. Furthermore, the amendment calls abortion a healthcare decision. And this is wrong on so many levels. The pro-abortion side often intentionally confuses convenience abortions with healthcare. And this amendment muddies the waters, makes it more confusing. There was some comment also about this bill violating Article 1, Section 38 of the Wyoming Constitution, and it doesn't. In that section, the word abortion is not used. Abortion's not health care. The object of prenatal care is to protect both the mother and unborn babies. Therefore, abortion cannot be health care because it intentionally kills one of the physician's patients. There was some concern there about treatment of health conditions such as medical conditions such as ectopic, tubal pregnancies, spontaneous abortions, etc. And these are not abortions either. And this amendment really confuses that issue. I'd go on further to say that at conception, at that very moment, a new and unique individual is formed. All of the inherited features of this new person are determined, and I'll stand against the amendment.
Representative Ward for your second time. Oh, anybody else for their first time? Representative Ward for your second time.
Thank you, Mr. Speaker. In accordance with Rule 12-4, I ask for the ayes and the noes on this amendment.
Is there a second? Second by Jennings. Anybody else for their second time? Representative Penn for your second time.
Thank you, Mr. Speaker. So I was reminded of the terminology that was used for this bill in reference to abortion not being healthcare, and the language was used that it's a medical procedure. I would agree with that. Abortion is a medical procedure. No one's arguing that, and that terminology is not found in the bill nor in the amendment. Let me help you understand a little bit about what the medical procedure is. For many of these abortions, it's called a D&C, a dilation and curettage. And in the emergency department, where I've spent many shifts, we see a lot of women that come in with what we call threatened abortions or spontaneous miscarriages. And they come to us with heavy bleeding and things. And sometimes it's medically necessary when the pregnancy has already spontaneously been miscarried, that we perform these D&C procedures in order to potentially save the life of the woman. If the products of conception are not completely expelled, it could be a fatal hemorrhage that could result. And so after we've obtained an ultrasound and made sure that this is a non-viable pregnancy, sometimes we'll try medications first to see if we can get the bleeding to stop. But if those attempts are unsuccessful, then a D&C is indicated. It used to be that these procedures would be performed in the emergency department or in physicians' offices. But thankfully, recently, and by recent, I mean the last 15 years, that standard of care has changed to where these women typically get taken to the operating room. And the reason for that is because this is a fairly barbaric procedure. In fact, some of the older nurses that I used to work with who used to participate in those D&Cs, those life-saving D&Cs in the emergency department, it was just difficult for them to be a part of, because it's something that needs to be performed under anesthesia. And oftentimes these things in abortion clinics, they're performed in the office without anesthesia, sometimes without medications. It's very painful, it's very intrusive. And it's difficult even for the staff to participate in if that woman isn't sedated. So yes, abortion is a medical procedure. I would agree with that. And I would second the comments from before that does not equate to health care. Once again, on and against.
Anybody else for their second time? Representative Brown, bring us home.
Thank you, Mr. Speaker. So I want to be clear. This is not my personal feelings, okay? I am literally bringing forward the concerns, the frustrations, the amount of 2.5 hours of discussion out here on this floor. I'm trying to bring that into an amendment. And if we don't pass it, I'm okay with that. I am okay with that. I can't vote for this bill the way it is, but I'm okay with not passing this amendment. I also want to be clear that at the end of the day, the amount of abortions that are performed in this state through the operations that we just discussed, the last time I checked was probably 4 years ago, and it was 5 abortions had been done in the past 15 years. So 1 every 3 years. This bill, frankly, it's not going to change anything in my community. Probably not going to change anything in the Sheridan community, probably not going to change much in the Gillette community, and probably not going to change much over in the Evanston community. Because the people who are going to want abortions are just going to leave our state and go have abortions. We can outlaw them all we want here. I'm fine with that. I'm okay with that, and I support that. Okay? What I'm trying to do is make good policy. I am not trying to attack this bill. I am not trying to tell you not to vote for this bill. That's on you. I am trying to make a bill more palatable for me and for some of the others that I heard talk about this bill yesterday. At the end of the day, the body will choose, and I'm okay with that. So I do want to say one thing, 2 things here that was discussed about conception. I struggle and I worry about the idea of conception being the utilization inside this bill. Something may happen, the doctor performs a procedure, an abortion occurs. They didn't know that the person was pregnant because conception had just happened maybe a day or two prior. That's why I tried to bring in the heartbeat portion of this. Again, I don't necessarily see it that way. I see when that cell splits, that is life, that's me, okay? But I'm trying to see from another point of view as well, and there are others that see it that way. And the last thing that I want to say was the discussion about the detection of a heartbeat. I actually agree with the good provider, and it's really good. It's really awesome to actually have a provider in this body, and I appreciate it. I work with providers all day, every day. And the idea that once a heartbeat can be detected should have been brought into this. And if this bill or if this amendment's brought in, I promise I will bring a third reading amendment to change it to that, because that is actually the correct way to word this. What I wanted on that particular side of things is to make sure that we did have a bill that passed out of this body that says, if you're going to have an abortion, you have to hear the heartbeat first. We passed that in 2017. And I supported that bill too. So I would urge an aye vote. I'm trying to make this bill better. Some may not see it that way, and I understand that. I do promise to try to work with the bringers of this bill to try to make this more palatable for everybody, but as the good speaker said, there was more than the majority of those present last night when we decided to debate this bill for 2.5 hours and we moved it out of committee of the whole. So on and forth. Thank you, Mr. Speaker.
So on the question of whether second reading amendment number 2 to House Bill 155 should pass, Chief Clerk, please call the roll.
Elleman? Allred? Andrew? Angelos? Banks? Bear? Berger? Brown? Burkhart? Byron? Chadwick? Chestick? Klauston? Conrad? Craigo? Davis? Eklund? Haroldson? Harshman? Heiner? Henderson? Hornock? Jennings? Knapp? Larson Lloyd? Larson JT? Lawley? Locke? Nyman? Newsom? Nicholas? Nemec? Northrop? Oakley? Obermuller? O'Hearn? Olson? Ottman? Pendergraft? Penn? Provenza? Rodriguez-Williams? Sherwood? Singh? Slagle? Smith? Stith? Storer? Strock? Stivar? Tarver? Trujillo? Walters? Ward? Washit? Western? Winter? Wiley? Yin? Zwanitzer Dan? Zwanitzer Dave? Speaker Summers?
No.
Zwanitzer Dan, can you repeat? Are there any changes? Closing vote. Vote closed. 6 aye, 56 no.
Second reading amendment number 2 to House Bill 152 has failed. Next amendment for our consideration, Representative Henderson.
Thank you, Mr. Speaker. I move second reading amendment to House Bill 152 and ask for your favorable consideration.
That's second reading amendment number 3.
Sorry, I say again, I move third reading amendment, second reading amendment number 3 to House Bill 152 and ask for your favorable consideration. The members, I have a technical issue with one of the things here, and given the results of the last decision, I'd like to divide the amendment. And it's a simple division. And it's Division 1 if you say it's okay, Mr. Speaker.
Please bring your division. No, at the mic. So go ahead. Voice your division.
English is a pesky language.
Please, Representative Henderson, go ahead.
Thank you, Mr. Speaker. The first division, my friends, is line 1 through line 22. And I would just briefly say, I've got, I'll bring it back on 3rd, but I've got a technical correction there. We made a decision on the last one there. And so what I'd ask you to do is, if it's okay, Mr. Speaker,
I rule that as divisible.
and then the second division is 2, and that's from the rest of the amendment down at the bottom there, lines 23 to 27. With your permission, Mr. Speaker, respectfully, body, I would like to withdraw, Division 1, if that's acceptable.
You know, that's a great question. I don't think you can do it. Once you divided it, it's,
All right,
it's,
well, then I understand. Mr. Speaker, I would ask for the question, and I would ask everyone to vote no on Division 1.
anybody else want to speak on Division 1? All
Question.
those in favor of Division 1 of second reading amendment number 3 signify by saying aye. All those opposed? Division 1 of second reading amendment number 3 has failed. We are now on Division 2. Representative Henderson.
Thank you, Mr. Speaker. I love it when a plan comes together and we have consensus. On Division 2, what I'm trying to do, and I'm not a doctor, but I did work in the Veterans Hospital for a period of time as a nursing assistant on the surgical ward. I do have some understanding of procedures in healthcare and treatment and so forth. And so words matter and rights matter and lives matter. I believe in life from conception throughout life until natural death. But I don't have a crystal ball and I'm not God. But I do believe that people have a right to make their own decisions regarding their own life and so forth. And one of the things that we do in life is we have definitions. And I think a key definition, given all the good discussion that we've had on this important bill, is the definition of healthcare. And so I just submit that definition. You can read it. There's maybe other words, key words in here. We talk about conception. Pregnancy doesn't happen instantaneously. And time is of the essence. It takes up to, I'm told, I haven't had any kids, but I'm told it could take up to 24 to, 72 hours for the sperm and the egg to make conception. We had the good definition yesterday from one of the good people about fertilization. And so I would just submit that it's worthwhile at this important point in this process to consider a definition for healthcare, and I'd ask for your favorable consideration. Any questions? If there are no questions, I call for the question.
Representative Bear for your first time.
Thank you, Mr. Speaker. I find this so vague, I really don't understand it, and I usually do try very hard to grasp these things. It seems to me that if we're going to define what healthcare means in very particular terms, we're going to have to spend some time at that. It's a very large and encompassing subject. So if the bringer of the amendment could just explain what it is he's trying to accomplish with this, otherwise I'm afraid I cannot support the amendment.
Anybody else for their first time? Representative Rodriguez Williams.
Thank you, Mr. Speaker. Unopposed to the amendment, I think it's interesting that the word equitable is used because there's nothing equitable about abortion. I stand opposed and encourage a no vote.
Representative Haroldson for your first time.
Thank you, Mr. Speaker. So I'm looking at the definition side here, and it states healthcare means the provision of safe, effective, timely, equitable, and integrated medical care to persons, including a community. And then I go to the definition of healthcare as of a well-known dictionary, and it says the maintaining and restoration of health by the treatment and prevention of disease, especially by trained and licensed professionals. So that's the definition of health care. And so I'm not quite sure where this definition came from, nor is this the place in statute to put it. So I would say on and against, just simply because I just don't know if this is exactly how we want to place healthcare in codified law.
Anybody else for their first time? Representative Jennings for your
First, second.
Anybody else for your first time? Representative Ward for your first time.
Thank you, Mr. Speaker. Healthcare is for individuals, not a community. Thank you.
Anybody else for their first time? Representative Hornock for your first time.
Thank you, Mr. Speaker. Just going through this definition, let's just think about the words here. First, safe. Sometimes in the medical field, you have to break something in order to fix it. Effective. Sometimes there's options of what is most effective treatment, and there's choices in that. So I think that's kind of difficult. Timely. Some people don't know perhaps they have cancer until it's way too late. So how do we kind of define timely? And then equitable, that's been brought up before. So anyway, this is just a little bit sticky on the whole healthcare side with defining it using these terms. I would urge a no vote. Thanks.
Anybody else for their first time? Second time before the bringer, Representative Henderson.
Thank you, Mr. Speaker. Appreciate the good debate. Responding to the comments, just briefly, remember I've been bringing up the idea of rights and the protection of life. And I think everyone has a right. That's women, that's unborn babies, and mothers, as pertains to this bill. Regarding the definition, I did get calls and talk with people who are in the profession of healthcare, medical providers, and that's where I got this, the context of this definition as a start. As far as a community, I would just suggest respectfully that the family is a community, a hospital is a community, made up of individuals, of course. And I would just call for the question. Thank you, Mr. Chairman.
All those in favor of division number 2 of second reading amendment number 3 signify by saying aye. All those opposed? No. Division 2 of second reading amendment number 3 has failed. House Bill 152 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is House Bill 154.
House Bill 154, sponsored by Representative Banks, permanent vehicle registration, an act relating to motor vehicles.
House Bill 154 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is House Bill 164.
House Bill 164, sponsored by Representative Zwanitzer Dave, legal notice publication on websites, an act relating to the publication of legal notices.
House Bill 164 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is House Bill 174.
House Bill 174, sponsored by Representative Andrew, homestead exemption amendments, an act relating to the Code of Civil Procedure.
We have amendments. Representative Andrew.
Thank you, Mr. Speaker. I move Second Amendment reading number 1, House Bill 174, and ask for your favorable consideration. Members, yesterday we amended in the bill the homestead exemption limit down from unlimited to 50,000. This is a great boost from the current 20,000 in law, but I wanted to bring to the body the option of 100,000. This is important because there are a lot of situations in which someone would be required by default to sign a personal guarantee on a loan. Probably the most common example where you have to do this is an SBA loan. You don't specifically sign over the right to your home, but that is in fact what you are doing. A bank could still require that a person specifically sign their home over to secure a loan, and this would not apply, but at least the action would be very intentional. People should be protected from collection of unsecured debt, at least to some extent. The original statute created in 1886 set the limit at $10,000, which adjusted to inflation would be $315,000 today. $100,000 gets us a lot closer to the original intent, which I believe was to protect someone's whole home. Thank you, Mr. Speaker.
Representative Chestick for your first time.
Thank you, Mr. Speaker. On and for the amendment. I am a co-sponsor on this amendment. This section of law protects debtors, protects people who have gotten themselves in some trouble. Maybe they had some medical bankruptcy or medical issues that they were unable to pay. There's judgments against them. It does not interfere whatsoever with any mortgage or other voluntary lien that's been placed on the property. But if there's an unsecured debt and there's an attempt to collect on this unsecured debt, this bill provides some relief to the debtor so they're not completely destroyed by the debt. They will be able to keep the first $100,000 beyond any liens that be paid off first, and therefore since it provides protection for people who may be in financial trouble through no fault of their own, it gives them some protection to be able to start over and not be destroyed by the debt that they may have had no involvement in getting into. So I'm very much in favor of this amendment.
Anybody else? Sensing your urge to vote, all those in favor of second reading amendment number 1 to House Bill 174 signify by saying aye. All those opposed? Second reading amendment number 1 to House Bill 174 is passed. House Bill 174 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Representative Angelos, did you have a privilege?
Thank you, Mr. Speaker. I do have a privilege. I'd like us to look up, I'm trying to see where she's at. I would like to introduce Janelle Oberlander, who is the Gillette Community College District President, down here visiting. Thank you, Janelle.
Welcome to the House. The next bill for our consideration is House Bill 188.
House Bill 188, sponsored by Representative Winter. Wolf, depredation, compensation, an act relating to agriculture.
House Bill 188, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Mr. Majority Floor Leader. Little conversation, I think. This next bill's got a few amendments, so maybe we want to wait till right after lunch.
Mr. Speaker?
Please.
Move the House stand in recess until 2 p.m.
You've heard the motion. All those in favor say aye. All those opposed, no. We stand in recess until 2 p.m. Okay, committee announcements. Representative Chairman Burkhart.
Thank you, Mr. Speaker. Your committee number 9, Minerals Business and Economic Development, will meet at 8 o'clock tomorrow morning, but will not start considering bills until 8:30. At that time, we'll consider Senate File 176 and Senate File 122.
Chairman Washit.
Thank you, Mr. Speaker. Your committee number 1, Judiciary, will meet tomorrow morning at 8 o'clock in our normal room to consider 3 bills, Senate File 24, Senate File 34, and Senate File 31.
Chairman Newsom.
Thank you, Mr. Chairman. Your committee number 6, Travel, Recreation, Wildlife, and Cultural Resources, will meet at noon, adjournment about 10 minutes from now, or 15, grab some lunch and we'll be there. We will consider Senate SJ 0007, support for Taiwan.
Chairman Brown.
Thank you, Mr. Speaker. Your committee number 8, Transportation, Highways, and Military Affairs, will be meeting in about 10 minutes to hear Senate File 14, Wyoming National Guard Professional Malpractice Liability, Senate File 15, Military Leave for State Employees, and Senate File 17, Off-Road Recreational Vehicle Safety and Insurance.
Chairman Nicholas.
Thank you, Mr. Speaker. Your House Appropriations will meet on adjournment to have Senate File 57 and Senate File 96.
With that, we will stand in recess until 2 p.m.